Good morning, good afternoon, good evening, wherever you are in the world, joining us for this webinar on the issue of cybercrime prevention strategies, future trends, and the rule of law. I'm Julian Clark. I'm the Global Senior Partner of the international law firm Ince, and also the Chairman of the Cybercrime Subcommittee of the CMI. Joining me today on this panel are Ken Gamble, the Executive Chairman of Internet Fraud Watchdog in Australia, Dr. Mohammed Chawaki, the Chairman of the International Association of Cybercrime Prevention in France, Mohammed Isa, who is a Senior Associate with my firm Ince in our Dubai office, and Colette Kelly, who is a partner of Ince and is our criminal and regulatory partner specialist. So, without more ado, let's start this very fascinating discussion by me handing over to Ken Gamble. Ken.
Well, hello everybody and welcome to the webinar. Thank you very much for joining us. My name is Ken Gamble. I'm the Executive Chairman at IFW Global in New South Wales, Australia, as well as on the board of directors at the International Association of Cybercrime Prevention in Paris, France. It's my pleasure today to present on technical challenges of cybercrime in 2021. Cybercrime is a topic that I'm very passionate about and have been for probably the last 15 years of my 34-year career as a fraud investigator. And I'd like to share some of my insights and some of my experiences that I've encountered out on the front line of fighting cybercrime around the world. I've got a brief presentation that I'm going to present to you today with a few slides just to give you a little bit of an insight into my world of cybercrime fighting. Now, there are many different types of cybercrime. We all know about the traditional cybercrimes. I won't bore you with going into all those, but of course, hacking attacks, espionage, Ponzi schemes, there's a lot of these original type of cybercrimes that we're all becoming very familiar with. But there's also new age cybercrimes that are starting to emerge that we're probably not real familiar with. Something like algorithmic trading scams. Some of you may not know what that is, but these are crimes coming out of the world of cryptocurrency. Now, crypto has exploded in the last couple of years. Crypto fraud, crypto scams absolutely exploded. A large portion of the work that's coming in to IFW Global on a daily basis relates to crypto frauds of some sort, whether it's a hacking, whether it's a scam, whether it's some sort of investment or forex trading. It comes in all different shapes and sizes, but it is an absolute huge problem and one that we can see is going to get worse. Even crypto jacking, it's not something that we get to hear too much about, but cryptojacking is where cyber criminals take control of your computer and use your bandwidth, covertly, of course, to actually mine crypto using your bandwidth and your data. And of course, most of these criminals that do this sort of work are involved in, or this sort of crime are involved in all sorts of nefarious activities. As innocent as using someone's bandwidth may sound, they're actually involved in some pretty serious criminal activity from wherever they may be sitting in the world. And of course, unmasking these people is one of the things that we have been involved in doing for quite some time. The images that you see on the screen sort of portray some of our operations that we've been conducting over the years on traditional cybercrime gangs. That is, criminals that are using the internet to commit normally investment fraud, some sort of cyber fraud, and also cyber money laundering, using the internet to conduct the laundering of money, cleaning money to end up in their pocket so they can buy assets and use them, for the normal things that criminals like to use that money for. Some of these operations were in the Philippines, and these are traditional gangs that are traditional gangsters. So a lot of these criminals that have gone into cybercrime come from traditional crimes. Some of these people might have been previously serving prison sentences for drug trafficking, but now they're involved in cyber crimes because that is where the money is. It's a high highly profitable, low-risk crime. Very few of them are caught. Very few of them, even the ones that are caught, very few of them are actually convicted of crimes. A lot of them get off. The charges are dropped. They might pay their way out in some cases. So it's kind of become an extremely lucrative criminal industry. And there's two types of criminals that are in this industry. There's those that have come from traditional crimes and got into this business and are probably not so tech savvy. And then you've got the new age, high-tech, state-of-the-art criminals who haven't come from traditional crimes. They've been born into these high-tech investment type frauds that have come from legitimate industries such as the financial services industry, the banking industry, and other types of industries where they have been involved in normal, clean operations, but they've gone to the dark side now because they've seen an opportunity to make an enormous amount of money doing some sort of crypto trading crime or something similar. The criminal organisations that have developed from these crimes have become enormous. We know of groups that involve thousands of employees sitting in call centres in countries like the Philippines, in Ukraine, in Bulgaria, in Georgia, in Serbia, in Belgrade, in Cyprus. These are the countries that are housing these types of cyber criminals in very large-scale groups. Call centres with hundreds and hundreds of people employed under some guise of being a legitimate business, but in fact they're conducting large-scale fraud, investment fraud operations, targeting 30 or 40 different countries, multiple different languages around the world. So the cybercrime organisations themselves have become very large, very sophisticated, very state-of-the-art, and very difficult to track down because of the infrastructure that they've put in place. They employ private investigators, they employ lawyers, they employ former intelligence personnel, they employ former law enforcement personnel to protect their operations. Of course, always under the guise of having some sort of legitimate business. But in fact, they're purely evil and criminal operations, usually targeting vulnerable victims from countries like Australia that may invest in some sort of crypto scam or otherwise and end up being in financial ruin. These types of crimes that are committed online by these cyber criminals can be extremely harming for the victim because not only do they leave the victim in financial ruin, but they leave the victim emotionally devastated as well. So it's a crime that not only has a monetary loss, but a huge economic loss and a huge emotional loss for the victim of these crimes. These victims never recover. And I can't understate the damage that it's doing to our country in Australia, as well as many other countries around the world. Some of these gangs have been caught in recent years, and 2021, I believe, was a turning point for law enforcement. Some of our local and foreign law enforcement agencies are now taking this matter seriously. These are seriously highly organised transnational criminal syndicates that are making millions of dollars out of illegal activity with very few organisations coming after them. So you can imagine why it's such a highly lucrative type of crime to be involved in. The crypto trading scams is something I want to talk about today because I believe, based on the profits that we see made by these groups, that this is probably one of the most profitable and lucrative cyber crimes on the planet. They make an enormous amount of money in a very short time. These type of platforms, such as the one on the screen called Oil Profit, these are marketed on a daily basis to Australians and other countries in other languages to get people to sign up into some sort of wealth creation scheme that involves a trading platform, usually trading cryptocurrency of some sort. When someone registers on one of these sites, they're put through to a call center in the Ukraine or in Bulgaria or in the Philippines. And within a matter of minutes, they're getting contacted by somebody in customer service that wants to sign them up and start on this journey of deceit and deception, of where they believe they're starting to make all this money. But in fact, it's a horrible crime in progress because they're duping the victim into believing that they're making a lot of money. So people put their life savings into these things, believing that they're becoming wealthy and that their money is going up and up and up. But in what's really happening is that they're getting drained of all of their money. Their money's actually gone immediately, and the criminals are just bleeding them dry before they finally land that devastating blow, and the realization sets in that they can no longer take their money out of these platforms. And then in a very short time, the platform shuts down and is gone. And of course, when they go to make a complaint, law enforcement can't really do anything to help because they know that the offenders are offshore and that it's very unlikely that the offenders are going to be caught. Now, in 2021, we saw, I think, an unprecedented level of law enforcement action, particularly in Europe, and particularly against Israeli Forex fraudsters who were running these types of platforms, the very platforms that are targeting Australia on Facebook and other social media platforms. Now, these scams traditionally were Forex trading, money going into bank accounts, credit card payments, but now they're almost exclusively turned to cryptocurrency. And all of the money paid to these fraudsters or paid into the platforms is crypto. And the money's laundered through crypto mules around the world in different countries, through both regulated and unregulated crypto exchanges, making it extremely difficult to track. It's not impossible to track because Bitcoin is traceable. It's traceable at least using the right software to be able to trace it to an exchange and find out where the money was cashed out. And then law enforcement is able to obtain the KYC documentation used to open up that particular wallet in that particular exchange. Now, very few law enforcement agencies are motivated to go after these types of criminals, even though some of these crimes are in the multi-millions of dollars. I know that our own law enforcement here in Australia has been hampered for many, many years with a lack of resources and a lack of budgets to be able to go after these types of cyber criminals internationally. And they have become massively enriched, these organisations, these criminal organisations, in order to carry out their crimes and use this state-of-the-art marketing to get victims to sign up in their scams around the world. So whilst we've seen a dramatic increase in law enforcement action, it's only a very small proportion of these gangs actually being taken down, but it's a start. And it's one I think has created a lot of interest from those agencies that are not taking action in some countries, looking onto their looking to see their fellow law enforcement agencies in other countries taking action. It's now creating some momentum. And I think we're going to see a lot more of this. I'm hoping in the next year, particularly maybe even this year, we may see a lot more of these types of raids. Now, the greatest dilemma that we have in Australia, and that I know that they have the same dilemma in the UK and also other countries around the world, is the law enforcement dilemma. This is the classic dilemma that comes along with particularly investment fraud, crypto fraud, all types of cyber crimes. There is this kind of an ongoing dilemma with cybercrime being, mostly unreachable. I think the most prolific type of cybercrime that's not being investigated is fraud. A lot of other traditional cybercrimes do get investigated, but we see it when it comes to fraud, which is the most profitable crime of all. We see a common excuse of it's out of our jurisdiction, we have no resources, we can't extradite, or it's too expensive to extradite, we have no budget for these operations, the offenders are overseas, it's not really our problem, and most importantly, we have other crime priorities, which has prevented our law enforcement here in Australia from going after a lot of these gangs. And I'm hoping, and I'm sure a lot of victims are hoping, that this is going to change. That's about it for me. My time is up. I could talk all day about this topic, but I want to thank you again for joining us, and I hope you enjoy the rest of the webinar. If you have any questions, my contact details are on the screen. I'd love to hear from you, and I wish you all the best for the rest of the webinar. Thank you for your attention.
Hi, everybody, and welcome to our webinar dealing with cybercrime. I am Dr. Mohammed Shawki, Chairman of the International Association of Cybercrime Prevention. located in Paris, France. I would like to thank Ince law firm for organizing this webinar with our association. I would like also to thank all the speakers and participants in this webinar. So let's start our presentation. So I have 15 minutes. I will be doing a presentation on tackling cybercrime in Egypt, and I will explain in details the legislations in force that have been adopted in this subject. I will start my presentation by some basics in information security. Information security in general has three main principal objectives. First of all, confidentiality of information. This means that only authorized persons can access the information, and accordingly, we fight against computer and network hacking and threats. Secondly, availability of information 24 hours per week. This means we find the data and information available according to our need. Finally, the protection of the integrity of information. This means that nobody can modify the data and information that we have saved. Risk management. The risk in information security, as you all know, is a possibility for an offender to find security gaps in computers and networks and make an impact. The impact can include adding data to the system without authorization, modifying or deleting data, adding spywares, etc. So in general, the risk in information security is cybercrime. In information security, we have a very important tool. We don't have a computer system that is secured 100%. I give you the example. We have teenagers who succeeded in hacking the database of the Pentagon, American Ministry of Defense. On such a basis, managing the risk is the best thing we can do because the risk costs us money, and the absence of security measures and security means costs us a lot of money. So, an important point for this presentation, we need to have a practical definition of cybercrime. There are many definitions proposed in Europe, the USA, and Africa about this threat. Sometimes we replace the word cybercrime by computer crime or ICT's crime or high-tech crimes to refer to offenses committed in cyberspace. According to the definition proposed by the United Nations, a computer system can be object, support, or tool for offenses. A computer system object for offenses such as zombie networks, computer hacking, sending computer viruses to computers and networks, etc. Tool for the offense such as identity theft, money laundering, etc. Here, the computer or the network has been used as a tool to commit the offense. Finally, support for the crime, such as saving information of data concerning a crime on a computer. There is no doubt that cybercrime is a growing threat and growing concern to countries at all levels worldwide. According to statistics, 154 countries have enacted cybercrime legislation to date. Europe has the highest adoption rate, 93%. Asia and the Pacific has the lowest rate, 55%. This represents a big challenge because we can't fight against cybercrime without the adoption of specific legislations. In other words, we have 79% of countries with legislations, 5% of countries with draft legislations, 13% of countries with no legislation, and 3% of countries with no available data. Since we are dealing with Egypt and Africa, what is the current status of cybercrime laws in Africa? Some African countries have embarked on designing and formulating ICT policies, but the majority of them are still in the early stage of cyber legislation development and enactment. Only few countries have moved ahead and have enacted cyber laws. Examples of these countries include Egypt, South Africa, Algeria, Senegal, and Morocco. So back to Egypt. ICTs have developed, as we can see, rapidly in Egypt in the previous years, with an increase in the number of internet users. The Egyptian Ministry of Telecommunications plays an important role in this subject. If we look at the current slide, there were 59.19 million internet users in Egypt in January 2021, compared to 55 million users in January 2020. The number of internet users in Egypt increased by 4.5 million between 2020 and 2021. The internet penetration in Egypt stood at 57.3% in January 2021. Now, some statistics about internet usage in Egypt. Egypt is classified as the second country in Africa by internet users after Nigeria, and the 19th worldwide. In 2021, we had 3 million users on Twitter and 38 million users on Facebook. Now, an important point, the legal framework to fight against cybercrime in Egypt. As you can see from this slide, Egypt has adopted many cyber law legislations for data protection, electronic signature, cybercrime, and protection of minors. The most recent law is a law number 151 for the year 2020 that has been adopted 2 years ago regarding the protection of personal data and the regulation of transfer of personal data between public entities. 4 years ago, Egypt adopted cybercrime law number 175 for the year 2018. The third part of this law, started from Articles 13, has a long list of offenses, such as unauthorized acts offenses, which is punished by fine and imprisonment. We have also crime of exceeding the right of access. The law has also crimes like sniffing, which is punished by either imprisonment or fine. We have a very interesting article in this law, which is Article 30, that deals with the liability of internet service providers. If internet service providers in Egypt don't block websites of illegal nature, such as child pornography, terrorism, cyber crimes, or hacking, and that's according to a decision rendered by the competent court, there would be a punishment, which is imprisonment or fine, or both penalties on the legal representative of the internet service provider. In addition, webmasters are also responsible according to this law if they don't inform competent authorities of a crime that they know according to the nature of their work. Another important law in Egypt is a law number 15 for the year 2004. The law recognizes the electronic signature as a legal value. This law has a list of crimes that relate to electronic signature, such as forgery of electronic signature, forgery of accredited certificate, manipulation of electronic document, or unauthorized access to an electronic signature system. All these offenses are punished by imprisonment or fine or both penalties. After that, we have the Protection of Minors Law, number 12, for the year 1996. In the Egyptian legal system, a minor is a person under 18 years old. According to this law, there are 4 main offenses: cybering, grooming, exposure to obscenity, and possession of pornographic material. We should know that having child pornography material for your own use in Egypt is considered a crime. Many people don't quite understand that concept. In Egypt, it is an offense whether it is possession, advertising, transmission, distribution of child pornographic material. This will cause the offender to be sentenced up to 2 years of imprisonment and payment of a fine. Furthermore, internet service providers in Egypt are not liable for the pornographic material placed on their systems as long as they don't have actual knowledge of these contents. Once notified, internet service provider should remove the pornographic material within reasonable time. Otherwise, there will be a suspension of their services. Another important point in the Egyptian legal system is the construction of economic courts in Egypt. Economic courts in Egypt have jurisdiction over economic issues in both civil and criminal proceedings, including cybercrimes, the stock market, the Central Bank of Egypt, intellectual property, and other matters. Economic courts are defined by the Economic Courts Law number 120 of the year 2008. These are special courts that examine cybercrime. Finally, in Egypt, we have a special cybercrime unit. The cybercrime unit is a specialized section within the Egyptian Ministry of Interior. It was set up in 2002. Its main role is to provide technical assistance in the detection and investigation of cybercrimes and to help victims. The unit is made up of police officers who are highly trained in the investigation of crimes that take place in cyberspace. We have reached the end of this presentation. I have three main recommendations. First of all, laws need to conform to international standards and international models in order to be integrated with a global legal framework. Secondly, cyber law should be technology neutral. That way, the law is flexible and able to adapt quickly to the fluid global environment. Finally, awareness raising is very important, and that's the role of our organization, of our association, by the organization of conferences and seminars worldwide to fight against cybercrime. I have finished my presentation. Thank you so much. And here is my email in case you have any questions later on. Thank you.
Thank you, Dr. Shawki, for the informative session. My name is Muhammad Isa, Senior Associate at Ince, Dubai. Today, I'm going to address the cybercrime laws from UAE perspective. And in my session, I am going to address the cybercrime laws of the UAE. Here in the UAE, we have three laws have been enacted in relation to cybercrimes. The first law was enacted in 2006. The second law repealed the first law and was enacted in 2012. And the third law was enacted in 2021. Generally speaking, the UAE government recognizes the importance of having cybersecurity and cyber crime law. For they recognize such importance because normally cyber criminals choose to operate in countries where the cybercrime law is weak or doesn't exist at all. Therefore, law number 2 of 2006 was issued on 30th of January 2006, and it listed the criminal acts that are considered cybercrime so long as they have taken place online or on electronic device. These acts are number 1, intentional unauthorized access to website on information technology system. Number 2, forgery, which relating to electronic documents or a website or any documents stored on electronic device or website. Number 3, the law provides a protection to unauthorized access to websites and damaging or publishing or deleting its contents. Here, the law is more provide for severe criminal liability in case the website that its contents have been altered are relating to government organization or relating to any organization that stores confidential information. The same criminal liability applies to alteration of medical records and any information relating to data relevant to diagnostic of any diseases or any public health issues within the state. The law also addresses the issue of verbal abuse, blackmailing, and defamation. And obviously, the law addresses the issue of misappropriation of funds and getting access to confidential information relating to bank accounts and credit cards or breach of privacy in general. So This law continued to operate until 2012, when law number 5 was issued in 13 of August and repealed the law of 2006. The law of 2012 addresses similar issues and similar criminal activities that take place online, except for some updates relating to new crimes and new issues that developed over the time. One of the main updates in the law relating to the removal of the intention requirements for unauthorized access to website or information technology device. The previous law of 2006, or the first law of 2006, provides that intention is required for the act to be classified as a cybercrime activity taking place online or on electronic device. However, the law of 2012 removes the intention requirement, and it becomes the crime satisfies the criminal elements and subject the offender to criminal liability for the mere unauthorized access to website or information technology system, or even having an authorization to access but staying in the website or in the network or the system in excess of the limit of the authority. The 2012 law also increased the penalty for changing or publishing or altering data on the websites or the information technology system, and increased actually the penalty to be 6 months imprisonment and 150,000 fine up to 750,000. And the fine increases and the period of imprisonment increases to 1 year in case such criminal activity takes place during employment relationship, and disclosure of data, of course, when it takes place during employment relationship. Now, I will also address the issue of disclosing or obtaining confidential information about companies or financial institutions, which have also been addressed in the law, and the penalty has been increased to 1 million dirham and imprisonment there for publishing or removing the data relating to company or any economic entity, financial institutions such as banks or any medical records as well. In case of prevention of access to website, the fine has been increased, and the law as well provided more protection to financial information such as bank account details, credit card details. Bank statements have been included in the law to be protected, and the offender, of course, will be subject to 6 months imprisonment and a fine between 100,000 and 300,000 for the intended use of financial information in misappropriation of funds. So the mere intention of using such information or credit card details or financial information in committing a crime result in a misappropriation of funds subjects the offender to such criminal liability. As the penalty increases to 1 year and up to 1 million dirham in case the actual misappropriation of funds have taken place as a result of such cybercrime. The law as well here addresses the issue of forging credit card information or financial information, such forgery that results in misappropriation of funds or any activity relating to financial information that allows the offender to transfer the funds to incorrect bank accounts or misappropriate the funds. For the first time, spam emails have been included as one of the offenses in the law. And of course, collecting donations trading in antiques are considered cyber crimes in case such activities have taken place without a license. Spreading rumors and money laundering activities are included in the law of 2012, and this includes the person who manages or establishing a website in which the rumors or incorrect information have been included. This person will be subjected to criminal liability so long as he was involved and he was in charge of the website or the electronic device that has been used in spreading the rumors or incorrect information that aims to result in public unrest. Money laundering activities, of course, relating to the remittance of funds and electronic transaction relating to bank accounts and proceeds of crimes. I think the law of 2012 was a valuable update to the law of 2006 and was the main step in the UAE legislation to upgrade and to include new crimes in the law in order to prevent cyber crimes and increase the cyber security. Now, in the next slide, we are moving to the last law that was issued in the UAE on 20th of September 2021. This was the Federal Law number 34 of 2021 on combating rumors and cyber crimes. This law repealed the law of 2012 and provided a lot of updates and acts that are considered cyber crimes after the pandemic and the COVID-19 era during the last 2 years. The first point that has been addressed in this law is the definition of cybercrime has been included for the first time. In the previous two laws, there was no definition of cybercrime. And it was understood that cybercrime relates to any activity takes place online or using electronic device. But under this law, such activity, cybercrimes is defined as unauthorized access or use of website or its contents or any electronic device by a person not authorized or in excess of the authority. And the law also provided three main areas relating to unauthorized access to website. The first one is the law criminalizes the mere access to the website. This is the first area. The second area is criminalizes the access to the website that results in damaging its contents or altering its contents or deleting the contents of the website. And the third area and the last area of unauthorized access is to have the intention to obtain the information for the purpose of committing a crime or illegitimate purpose. And here the penalty is severe, especially if the website is relating to state or any government agency. And the same principle applies to websites relating to a media or financial or economic or commercial institution in the UAE. And the offender, of course, will be subject to similar criminal liability. Regarding the disclosure of information, the law of 2021 increased the penalty of disclosure of any information classified and relating to financial institution or economic entities in the UAE. It also doesn't authorize the person who commits the act from using this information or republish the information or spread the information on the internet or in any electronic or non-electronic means. Forging email addresses and websites for the first time have been included in the website, either such forgery relating to an individual or relating to a government entity, or relating to a company or commercial entity in the UAE. So the offender will be subject to the same criminal penalty. For the first time, we have gathering information about citizens and experts is strictly prohibited under the new law, and publishing rumors and incorrect news. For the first time, also the new law included provision relating to publishing adverse or incorrect information about other countries or to damage the image of other countries. And here, I believe the UAE is meeting its international obligations towards other countries by preventing residents in the country, in the UAE, from being here and publish information about other countries and cause any unrest for others. Promoting electronic currency or creating a wallet to collect funds for the purpose of investment or any other purposes or misappropriation, resulting misappropriation is strictly prohibited under the new law if such activity has taken place without a license. So in other words, the person who wants to introduce an electronic currency or wishes to have a wallet for people to transfer funds or to save the funds and to do some investments, such company or person is required to have a license by the relevant government authority in order to ensure that the funds of others is protected and will be invested in the suitable and legitimate means approved by the UAE government. This concludes my part of the presentation. Thank you very much for attending. And now I will hand over the presentation to my colleagues, Julian and Colette, from our London office in order to address the cybercrime from a UK perspective.
Thank you very much, Mohammed. As far as the UK is concerned, there isn't a single cybersecurity law. There is instead a patchwork of cybersecurity, privacy, and national security legislation that varyingly apply to specific organisations, specific sectors, or to all businesses generally. And the main laws in the UK are the Computer Misuse Act of 1990. That is the main UK legislation relating to offences or attacks against computer systems such as hacking or denial of services. There is the Data Protection Act of 2018, which sets out data protection requirements for national security and immigration, as well as other domestic areas of law. The Regulation of Investigatory Powers Act of 2000 governs certain investigative powers of law enforcement agencies, such as surveillance and interception of communication data. The Investigatory Powers Act of 2016 provides for additional investigative powers and creates criminal offences of unlawful interception of communications, which is subject to limited exceptions for legitimate purposes. And finally, the Malicious Communications Act of 1988, which relates to malicious and offensive communications, including if the intention is to cause distress or anxiety, or to convey a threat or information that is false. As well as various pieces of legislation, there is a raft of regulations. We have the UK Data Protection Regulation, GDPR. We have the Privacy and Electronic Communications EC Directive regulations of 2003. We have the Network and Information System Regulations of 2018, which imposes regulations on operators of essential services and relevant digital service providers. The Telecommunications Lawful Business Practice Interception of Communication Regulations of 2000, the Investigatory Powers Interception by Business, etc., for monitoring and record-keeping purposes regulations of 2018, and the Cyber Sanctions EU Exit Regulations of 2020. And it can therefore be seen that there is very much a patchwork of legislation and regulations concerning cybersecurity. So what of the various offences that can be investigated and prosecuted in the UK? There is jurisdiction to prosecute all Computer Misuse Act offences if there is at least one significant link with the domestic jurisdiction, and that means England and Wales, in all the circumstances of the case. Significant links can include the accused is in the home country at the time of the offence, the target of the Computer Misuse Act offence is in the home country, and the technological activity which has facilitated the offending may have passed through a server based in the home country. And offences are broadly in two categories: cyber-dependent crimes and cyber-enabled crimes. As well as offences under the Computer Misuse Act of 1990, hacking offences can also arise alongside criminal offences in the Data Protection Act of 2018, to the extent that the offence involves causing a computer to perform a function with the intention of securing unauthorised access to data. In England and Wales, proceedings for an offence under the Data Protection Act may only be instituted by the Information Commissioner or with the consent of the Director for Public Prosecutions, who is the head of the CPS. In addition, there can be offences under the Investigatory Powers Act of 2016, where it is an offence to intercept intentionally within the UK a communication in the course of its transmission by means of a public or private telecommunications system without lawful authority. So we've looked at hacking offences. Now let's look at the denial of service attack offences, again under the Computer Misuse Act of 1990. Cyber attacks in which the perpetrator seeks to make a machine or network resource unavailable to its intended users by temporarily or indefinitely disrupting services of a host connected to the internet using incoming traffic originating from many different sources, flooding the victim, making it difficult to stop the attack by blocking just one source. And under the Computer Misuse Act, offences of denial of service attacks can carry up to 10 years imprisonment. There can also be investigations and prosecutions for disruption and infection of IT systems with malware, and that can include viruses, worms, Trojans, and ransomware. The Computer Misuse Act also creates offences of unauthorised acts causing or creating risk of serious damage. This is designed to cater for computer misuse, where the impact is to cause damage to, for example, critical national infrastructure, and where the maximum penalty of 10 years available under Section 3 of the Act may be inadequate. The maximum sentence on indictment in the Crown Court is 14 years, unless the offence caused or created a significant risk of serious damage to human welfare or national security, in which case a person guilty of the offence is liable to imprisonment for life. The Computer Misuse Act of 1990 also creates an offence of distribution, sale, or offering for sale hardware, software, or other tools used to commit cybercrime. And the rationale behind the creation of this offence is the market in electronic malware or hacker tools, which can be used for breaking into or compromising computer systems. So we've looked at cyber-dependent crimes, but there are also cyber-enabled crimes. And offences can include phishing, scams, and mass marketing frauds, forgery and counterfeiting, intellectual property, malicious communications, cyberbullying, cyberstalking, and online harassment. I'm now going to pass over to my colleague Julian Clark, who will look at the enforcement of regulations and developments in the field of cybersecurity.
Thanks, Colette. Let's then turn to look at some of the ways enforcement of these regulations has impacted on those found to be in breach, and how the enforcement regime in the UK has been developing. As an example of recent enforcement I'm going to speak a little bit about what happened to British Airways. This incident involved the unauthorized access of BA's IT systems and a diversion of user traffic to the BA website to a fraudulent site, effectively a spoofing of the site. And what that did was it resulted in customer details being harvested by attackers. In fact, personal data of over 429,000 customers was compromised in this instance. The ICO investigation found that BA was processing a significant amount of personal data without adequate security measures in place. And it was this failure which effectively breached existing data protection law and subsequently led to BA being the subject of a cyber attack during 2018. And importantly, an attack which BA did not detect for over 2 months. The ICA investigators found that BA ought to have identified weaknesses in their security and resolved them with security measures that were available at the time. The investigators concluded that had BA taken advantage of the security measures which were available to them, then this would have prevented the 2018 attack. Now let's examine exactly what it was that the investigation said BA could have done. Well, there were numerous measures that BA could have used to mitigate or prevent the risk of an attacker being able to access the BA network. And these included limiting access to applications, data, and tools to only those which required their access in order to fulfill the user's role. Undertaking rigorous testing in the form of simulation of a cyber attack on the business systems. And indeed, I think that's a key note to take away for anyone listening to this webinar, the importance of cyber drills so that you know how to react, what issues to take place immediately to protect the business in the case of a cyber attack. And then protecting employee and third-party accounts with multi-factor authentication. In July 2019, in the first fine to be levied by the ICO under the UK GDPR regulations, the ICO announced its intention to issue a fine to BA of £183.89 million. Now, that fine was later revised to 20 million in October 2020, and that was to reflect certain mitigating factors, which included the remedial measures taken by BA in response to the attack, BA's cooperation with the ICO, the lack of aggravating factors, and the impact of the COVID-19 pandemic. So now let's just have a quick look at the enforcement of the NIS regulations. Well, as Colette explained earlier, there is no single unified law or indeed body which regulates all operators of essential services, OESs. The UK government has instead opted for sector-specific regulation. The NIS regulations also require OESs and relevant digital service providers, RDSPs, to report incidents to the relevant competent authority without undue delay. And the relevant authority in turn may inform the public where public awareness is needed, either to prevent or resolve any incident or where this would otherwise be in the public interest. But the organisation will be consulted before disclosure to the public is made, and that's in order to recognise and to preserve confidentiality, and commercial interest. Now, concerns have been raised that organizations suffering from a cyber attack, which results in the loss of both services and the access to personal data, could face a double liability of fines of as much as £35 million when considering that regulatory action might be taken both under the UK GDPR regulations as well as under the NIS regulations. The NIS regulations encourage that the enforcing authority should be reasonable and proportionate. That's the wording in the regulation, and taking into consideration whether the contravention is also liable for enforcement under a separate regime. And the UK government has indicated that it would limit the potential for multiple fines regarding a single event. So, for example, under the NIS regulations, but also under UK GDPR, by ensuring that regulators should take a common approach. However, it's important to note that the government have not ruled out the possibility that they will penalise organisations under different regimes for the same event, because the penalties may relate to different aspects of the wrongdoing and the different impact that the attack or the breach of the various regulations may have. Now, I should say something about the new Product Security and Telecommunications Infrastructure Bill, the PTSI. The government says that this proposed new law will require manufacturers, importers, and distributors of digital tech that connect to the internet or other products to make sure that they meet tough new cyber security standards. And there will be heavy fines under the new proposed law for those who fail to comply. And in relation to application, the new laws will apply not only to manufacturers, but also to other businesses, including physical shops and online retailers, which enable the sale of millions of cheap tech imports into the UK. So retailers will be forbidden from selling products to UK customers unless they meet security requirements, which will be rigid, and they will be required to pass important information concerning security updates to customers. The bill is intended to allow consumers to be better protected from attacks by hackers on their personal devices, which range from anything from phones to tablets, smart TVs, even fitness trackers, indeed any other internet connectable device. Now, this new cyber regime will be overseen by a new regulator who will be designated once the bill comes into force. And that regulator will have the power to fine companies for non-compliance up to an amount of £10 million or 4% of a company's global turnover, as well as up to £20,000 a day in case of ongoing contravention. So you can see it's another very, very significant fine regime. And the regulator will be able to issue notices to companies requiring that they comply with the security requirements, that if necessary, they recall their products or they stop selling them altogether. So in other words, very similar powers to the ICO. On the 19th of January this year, UK government published a review detailing the progress made in improving cyber resilience between 2016 and 2021, and what action is required in order to further enhance cyber resilience in the UK. And the review concludes that despite the positive impact of the UK GDPR regulations, the DPA 2018 and the NIS regulations of 2018, the market has failed to improve its security practices at a sufficiently rapid rate to keep pace with cyber threat and the development of cybercrime. So the UK government intends to take a more interventionist approach to encourage organisations to reduce cyber risks. And these measures will include to understand why government advice is not reaching the right target, to increase cyber resilience within organisations by an increased uptake of the Cyber Essentials scheme, to improve resilience with essential services and digital services, to increase accountability for cybersecurity within businesses, to clarify skills and qualifications of those within the cybersecurity profession. And on the 25th of January of this year, the first government cyber security strategy was launched. And this included establishing a new government cyber coordination centre to better coordinate cybersecurity efforts across the public sector. And Britain is now the third most targeted country in the world in cyberspace from hostile states. So it's quite clear that our critical functions need to be protected. Ladies and gentlemen, I'd like to thank you on behalf of myself and my other panelists today for joining us for this webinar. We hope that you found it informative and useful. And of course, as always, should you have any inquiries or queries whatsoever as a result of this webinar or the issues that have been discussed, then please feel free to reach out to myself or any of the panelists who would be delighted to respond to you. Thank you very much and keep cyber safe.